if you're not going to be speaking, that helps with the sound. I see Mr. Silver, and I have a DA for David Abney. Is that what we're getting for Mr. Abney? Are we going to have a video?
I have my camera off. I'll turn it on. Yeah. Can you see me now?
We can see you.
Okay. Sorry about that.
All right. I think we're all here. This is the time set for argument in Kunasek versus Johnson. It's our case number CACV 20-0061. Each side will have 20 minutes for argument. Counsel for appellant, you'll be required to reserve any time that you'd like to save for rebuttal. Hopefully you can see the clock down below.
Actually, mostly what we see is the clock.
You're not seeing the judges and Mr. Abney.
I learned this morning that if you click on someone's face, the clock will go to a small panel.
Okay. Excellent. Thank you.
Okay. So you can see the three judges and Mr. Abney now, hopefully?
I can. Thank you.
Okay. So these proceedings are being video recorded. They'll be posted on YouTube within a day or two. For ease of reference, it would be helpful if you would state your name and identify your client when you begin speaking. We have read the briefs, we've conferenced this matter, and we're looking forward to hearing from you. And with that, Mr. Silver, you may proceed.
Thank you, Your Honor, and may it please the court. Leon Silver from Gordon and Reese. We represent all of the Johnson defendants, but today I'll be speaking on behalf of all of the appellants and cross appellees. And I will try to reserve 3 minutes for myself for rebuttal. I have a clock here to watch as well. The briefs cover many reversible errors of law that led to the $21 million judgment that even the plaintiff called staggering. I would like to focus my remarks today on, and the court's attention on, 3 issues. First, I'd like to discuss the trial court's failure to follow Arizona law and the Arizona rules of civil procedure relating to the statute of limitations. Second, I'd like to address the court's failure to rein in expert testimony. I'll do that by focusing on Marlene Appel, who was allowed to invade the province of the jury by repeatedly testifying that in her legal opinion, the trustees were liable for breach of fiduciary duty, which was based in large part on her incorrect view of the law. Similar errors were made and were briefed regarding Mr. Zlackett, Mr. Duncan, and Mr. Gaintner, but I'm not going to get into those. Finally, and time permitting, I'd like to address damages, and in particular, the court's failure to provide the jury with an appropriate roadmap to calculating damages consistent with the law and without undue passion or prejudice. And as a result, I'll ask the court to vacate the judgment, terminate the cases to the aiding and abetting defendants based on the statute of limitations, and order a new trial with instructions regarding the issues raised in the briefs and discussed today. So first, I'd like to talk about the statute of limitations issues. Arizona Rule of Civil Procedure number 3 sets forth a very clear standard. A case is commenced by the filing of a complaint with the court. There's no rule that says a case is commenced by filing a motion for leave to amend and attaching it. That was something that the trial court decided on the fly without citing any authority and without doing any analysis. Rather, the allegations in the original complaint are binding on the plaintiff for statute of limitations purposes, and when the amended complaint was filed more than 2 years later, adding additional defendants, the same allegations, the same factual allegations, the same set of facts were relied on by the plaintiff to make the claims against the additional defendants. That was beyond the 2-year period. And specifically, George Johnson was mentioned, was a party to the original complaint, and every fact that the plaintiff has since tried to prove, has stated in the briefing, every fact about George Johnson can be found in the original complaint.
Rule 3 is a great rule, but what about Rule 15C? I mean, don't we have a relation back argument? I understand you're not going to concede it, but doesn't it exist?
It certainly exists, and there are certainly instances when relation back is appropriate. That was never argued in this case. It was never claimed in this case. And part of the problem why it couldn't be claimed in this case was because if you made a relation back argument, you'd have to be conceding that the facts were all in the original complaint. So the plaintiff chose not to make that relation back argument, and it was never addressed. The plaintiff claimed that it was making a new claim based on something learned in discovery, but there was nothing learned in discovery that changed the allegations from what was in the original complaint. And instead of relying on a relation back kind of argument, the court sort of did an equitable tolling analysis. But I say sort of because they really didn't get into the meat of the law on equitable tolling. Equitable tolling would require specific acts by the defendant that prevented the plaintiff from learning of the full nature of the loss sufficient to bring the claim. Well, that's not what happened here either. What the court decided was that it was going to adopt what is essentially the deeming rule that other jurisdictions have talked about. But the court did that without actually analyzing the full extent of those cases from the other courts and left off the two pieces of the deeming rule that are key. Well, one was here. Under the deeming rule, which is in the Mays case, and that's cited by Toy v. Katz, and in cases in other jurisdictions, an amended complaint is deemed filed with the filing of a motion for leave to amend if two things occur. One, a copy of the complaint to be filed is attached to the motion for leave to amend, and two, actual notice is given to all the defendants, including any to-be-added defendants. So in this case, yes, the amended complaint was attached to the motion, but there's no record, and the record is the opposite, that the defendants to be added received notice of the filing of this motion. Now that becomes important for due process reasons because in this case, there was extensive ongoing litigation. In fact, between the date of filing the motion for leave to amend and the date the amended complaint was actually filed, there are 27 separate docket entries. 16 motions were filed, 7 filings regarding the special master, 3 minute entries and an order were entered in that time period, and the 3 to-be-added defendants had no notice of this. So if the court is inclined to recognize some exception to Rule 3, which I submit this court should not do, Rule 3 is very clear, and this is not a relation back case, and it's not an equitable tolling case, it's a deeming case. If the court is inclined to recognize the deeming exception, I would submit that the court needs to adopt those 2 additional conditions to make that effective. And that didn't happen here. And the record is the opposite.
Counsel, when the new defendants were joined then after these 27 events, did they seek to set those aside?
Yes. And in fact, this is where the difficulty of how the trial court went about this becomes apparent. First, there were 4 new defendants. One, Mr. Travers, he filed a motion for summary judgment on the statute based on what was alleged in the original complaint, and it was granted. He was dismissed. George Johnson filed a motion to dismiss on essentially the same grounds, and that was where, in response, the trial court applied the deeming rule, which he said was raised for the first time at oral argument, and didn't cite anything. He just said,
saying Mr. Johnson was not on notice when the motion for leave to amend was filed? If he's already a party, how would he not have received notice?
Mr. Johnson had been dismissed from the case, And when the motion for leave to amend was filed in October of 2014, and 2 months earlier, the plaintiff's counsel had taken George Johnson's deposition. At Mr. Johnson's deposition, he had new counsel. He had a lawyer from the firm of Squire, Patton, and Boggs, as opposed to the lawyer who had previously represented him in the case. So plaintiffs knew he had new counsel. When they filed the motion for leave to amend, they didn't serve his new counsel. They served the original counsel, Mr. Nye, who in the record at that point was specifically representing Chris and Barbara Johnson, and not George Johnson. So the cases that go to this deeming rule all talk about actual notice being necessary. It's not, you don't have to serve it. It's not service of process, but it's actual notice, not constructive notice, so that the party has the opportunity to participate to the extent appropriate. So getting back to the process, when Mr. Johnson filed his motion to dismiss, the court, without citing any authority, with recognizing that there was no Arizona authority, essentially doing sort of an equitable tolling idea, decided to adopt this deeming rule without calling it that, and then and left it open for a record to be established. So then all of the defendants filed, or the additional defendants filed motions for summary judgment or motions for judgment on the pleading, seeking to address this issue and to address the factual issue behind the statute of limitations. And rather than readdress this deeming issue, the court just said, well, I've already ruled on that, and that was it, and just was done with it. So the court never actually addressed the meat of what this deeming rule is. And not having done that, the record, the record stands with, okay, in February of 2013, the parties knew, or the plaintiff knew what had happened to him. He knew who was involved. He knew that George Johnson had been involved. He knew that at least a lawyer who we identified as his own lawyer, who also gave advice to the trustees, was involved. Now, I'll submit there's only two possibilities and really only one, and that would be either Mr. Schneidman or Mr. Drummond. So he's certainly on inquiry notice. So he had an obligation to find out who these additional parties were within 2 years and to bring that before the court. He didn't do it. When he filed his motion for leave to amend, when he chose to do that, instead of just filing a complaint, which he was free to do, he could have filed a complaint within this time period and moved to consolidate. He chose not to do that. He also chose not to give notice to these to-be-added defendants. And for those reasons, this complaint should not be deemed filed with the motion to amend, even if the court is going to adopt that deeming rule. Looking at the time, with the court's pleasure, I'd like to move along to talking about the expert witness issues. It's well settled that there are at least two things an expert witness may not do, particularly a lawyer expert witness. One is invade the province of the jury by telling the jury how to decide the case. And the other is to invade the province of the judge by telling the jury what the law is. And in this case, the expert witnesses, and particularly Ms. Appel, did both. She, in her expert disclosure, her expert report, she repeatedly states that the trustees had breached their fiduciary duties. We filed a motion in limine barring her from saying that. The court said she can't say that, but she can talk about what the standard of care is, which is correct. She then comes to court and she testifies that this is the standard of care. She draws a line and repeatedly says, in my opinion, the defendants fell below this standard of care. Well, that's the same thing as saying they breached their fiduciary duties. That is the ultimate issue that she's not allowed to give an opinion on. And this was compounded. I mean, it was stated over and over again. And all she did was change it from breach fiduciary duty to fell below the standard of care.
Is the problem really, though, that she talked about the ultimate issue, or is the problem more that she talked about the ultimate issue in terms of a legal opinion?
Well, it's actually both. because she talked about the ultimate issue. She talked about it in terms of a legal opinion when it's really the standard is a lay person standard. And she then gave an undisclosed legal opinion, something we had no notice she was going to say, that the language in the trust agreement that cabined liability based on willful misconduct was ineffective in her opinion as a matter of law. So, that is something that the judge should have instructed on. We had no notice she was going to say that. So you put that all together and you have, as the first witness in the case, an expert who is saying, in my legal opinion, these trustees are liable, and you can't even pay attention to the language in the document that says that you have to make a specific finding of willful misconduct.
She's not saying they are liable. She's saying there's a standard of care, and what they did fell under the standard of care. There may be that may not equate to a breach of fiduciary duty. It may be a very minor violation of a standard of care that might not rise to the level of a breach of fiduciary duty. If it's something that's inconsequential, it seems to me there is a difference between a standard of care discussion and you must find that the defendant breached a fiduciary duty.
Well, I refer the court to Gibson v. Casey, 214 Ares 141. Failure to meet the standard of care and breaching the duty are the same thing. So, that's what she did. She said it over and over again. And even in closing, counsel argued in closing, we brought in Marlena Pell and had her explain and had you evaluate based on full information. And she told you not only did they violate their fiduciary duty, fall below that standard of care line, they intentionally and willfully did it. So they conflated it, certainly, that not having the judge instruct on this and allowing the expert witness who's a lawyer, there was no dispute that this witness was an expert, allowing her to explain this to the jury in that way caused all sorts of error. With just a little bit of time left and with your pleasure again, I'd like to just touch on damages. Again, there was a staggering damage amount here. We submit that the amount was far removed from the damage caused by the trustees. And the court had several chances to keep the jury from running away on the amount. First, the court could have bifurcated the case so that the punitive damages issues, the net worth of the defendants would not have been in front of the jury during the case. I submit if you look at exhibits 1 through 5, those are the net worth interrogatories of the defendants, and in particular, George Johnson's net worth is staggering and prejudiced the jury. The second would be the failure to rein in.
Wasn't it apparent to the jurors that there was significant wealth just by the nature of the case? Wouldn't they have been aware of the wealth, at least to a certain extent, even without that?
Well, certainly there's significant wealth, and then there's staggering wealth. And every juror, certainly lay jurors might have a very, very different view when they hear, when you see the difference. This stuff is submitted under seal, so I don't want to say the numbers, but if I'll refer you to, there's a reason plaintiff has exhibit number 1 being George Johnson's net worth out of 280 exhibits. That's number 1. And it is staggering and it is prejudicial. And then the issue gets compounded because the court failed to rein in the expert witness who testified that he was told to assume that all of the losses were caused by the trustees. And we knew that. We filed a motion on that and we objected at trial. But then he went on to say, which was undisclosed, that he, in his expert opinion, this was a legal, a reasonable assumption. The judge failed to give an instruction that we requested that would have differentiated between losses caused by the trustees and losses caused by George Johnson. This is the rare case where the aiders and abettors caused additional losses, but had the legal right to do so. So that instruction was necessary, and the reason given was just that it was late. And even the rule allows late filing of instructions, and we showed good cause, and there was no prejudice
Which instruction are you saying directed them to impute damages? I read the instructions as limiting it to damages caused by the individual defendants. Am I misreading those?
It's the instructions combined with the testimony, with the expert testimony on the assumption. We asked to have an instruction add that you may not award additional damages if you find that one or more of the other defendants aided and abetted. So the idea was to separate out the actions of the additional defendants and any losses that might have been incurred because of them from the other damages. And then, finally, there was this idea that we put before the court a remittitor motion. So when we look at the whole thing, if the statute of limitations had been properly applied, a lot of these problems would have been solved. George Johnson wouldn't have been there. We wouldn't have needed the bifurcation. There wouldn't have been an issue of assigning all of these damages to him. We wouldn't have needed this additional instruction. And that would have cleared a lot of things that didn't get cleared. I've got 1 minute left on my timer, so I'm going to reserve that time.
Thank you. Mr. Abney.
There we go. That might work. May it please the court, my name is David Abney. I'm representing Andrew Kunasek. Just for technical purposes, I take it I'm being heard at this time?
Yes.
Okay, great. Just a few comments first about the expert, and then to shift back to the statute of limitations, if I might. The expert was talking about the standard of care. It's not the same as duty. The duty is established by a court ruling that there is a duty or there is not a duty. And then you get into the standard of care when you're dealing with trusts, trustees, the sorts of relationships and duties that are involved there, and what you need to do to fulfill the duty of care.
Does a violation of a standard of care, why isn't that synonymous with a breach of duty?
Well, it isn't. In a sense it is, because if you have a duty and there's a standard of care and you breach it, then that's one of the elements that you need to prove negligence or wrongdoing, along with proximate cause and foreseeability and all the other things. But you can't really, if you start saying, well, standard of care and breach of duty identical, you start sort of melding into duty, and I think they need to be kept separate. There is a duty of a fiduciary nature dealing with trustees, but what do you do to fulfill the duty? That's standard of care. And so you have an expert to help the jury understand, well, what is it that trustees are actually supposed to do? And in this case, did the trustees do what they're supposed to do? And that's part of establishing the overall cause of action for breach of fiduciary duty. As far as the statute of limitations, we have the case from this court, Toy versus Katz, and maybe it slipped by me if my colleague mentioned that. I don't know if I heard it, but on page 89 of the Toy versus Katz case, it specifically says, if I can quote just a sentence, the filing of the motion to amend constituted commencement of the action for purposes of the statute of limitations. And then it cites to this Mays case from the 8th Circuit. And in the Mays case, the court says a number of courts have addressed the situation, and they have held that the filing of an amended complaint is deemed, the start of the case for statute of limitations purposes. I double checked that last night to make sure that that's still the rule of law across the nation, and it is. There was a marvelous opinion from the 10th Circuit from 2019, May versus Segovia, 929 Fed Third 1223, and at page 1223, the court says the same thing, that this is the prevailing rule, that when you file the motion for leave to file the amended complaint, then that's when the statute of limitations starts. And it makes sense. This case was unusual, in part, I think, because it was so massive. There were hundreds and hundreds of items in the record on appeal. And the timing was you filed the complaint back in February 20th of 2013. Then there was a motion for leave to file the amended complaint on October 29, 2014. And that just sort of froze in the court system for a while until it was finally granted on March 19, 2015. My colleague says in the opening brief that the statute of limitations against George Johnson surely began to run on February 20, 2013. Well, if you take that as where the statute of limitations began to run, the leave to file was 20 October 2014, well within the 2-year period after February 20, 2013. I think Toy versus Cats really controls this issue, and I don't know if there's much else to say about it other than there was a concerted effort, at least from Andrew Kunasek's viewpoint, and I think the jury must have accepted it based upon their responses to the interrogatories that were presented, that he was kept in the dark about what was going on for many months. The attorney that was representing him and representing the others at the same time, Attorney Schneidman, did not help him out by telling him what was going on. The trustees didn't tell him what was going on. George Johnson didn't tell him what was going on, other than he was dissatisfied with his failure to try to put pressure on the governor and on administrative agencies to stop fooling around with this organization. And so he finally, and he's getting periodic payments in 2011, even right at the end of 2011, he's getting some payments that leads him to believe, well, maybe there's really nothing going on bad. And then everything, of course, the roof falls in. And he discovers what's going on, and then gradually, so starts the First Amendment complaint. George Johnson's name there, and 3 counts: civil conspiracy, a cause of action for an accounting, and one for conversion. So he's in the lawsuit, and then he gets out on odd grounds, and then he's back in with the First Amendment complaint, and probably in his true position as an aider or abettor. He's instigating, he's pushing the trustees to do what they should not be doing, and that's a good, solid cause of action against him, and one that the jury accepted.
That was not knowable when the initial complaint was filed. How different is that? What are you saying triggered that? It's something new that came up in discovery?
Well, the depth of the connections and what George Johnson was actually doing as far as pushing the trustees, threatening the trustees, and forcing them to do what I think they were sort of inclined to do anyway, but forcing them to push Andrew Kunasek completely out the door, and to make sure that his interest in incredibly valuable property became worthless. So it's civil conspiracy is actually in some ways fairly close to aiding and abetting, but you've got to sort of have for civil conspiracy, there's an underlying tort that you agree to commit, and that's the proof for that was not really very strong as far as George Johnson was concerned. But what was strong was, and it became clearer and clearer as discovery went on, that he was substantially assisting and encouraging the breach of fiduciary duty. And so that finally appeared to be a viable cause of action. And when Mr. Casey realized that, he timely filed a motion for leave to amend, and then things got slowed down in the judicial system until it was finally granted. So it seems to me we're within the statute of limitations period under Toy versus Cats, and that's the rule of law across the country. So it's not just this court coming up with a strange rule that nobody can anticipate. It makes a great deal of sense, because you can get into situations where, like what happened here, things just bog down. And you could have a change of judge, you could have a judge get ill, you could have a judge overwhelmed, all kinds of things. And of course, the opposition comes in from the other side, which slows things down again. If they fight it hard, demand a hearing, you have a hearing, it all takes months and months, and eventually it's granted, and it should have been granted. As far as damages, just a few words.
Could you address bifurcation first, if you wouldn't mind?
Well, I think
it made sense to bifurcate here, given counsel suggesting staggering wealth is different than just a lot of wealth.
Well, I don't know whoever said staggering. I don't think I put staggering into anything I wrote, but and I don't remember seeing it. But Mr. Johnson and his family are immensely wealthy, and that would have been evident to anybody from the start of this. Once you get going, looking at anything, you would realize instantly, bifurcated proceeding, non-bifurcated, that you're dealing with an immense amount of money, because we're talking about
for a juror. And again, I don't know the amounts, but if for me as a juror, $2 million is a very wealthy individual, or say $5 million, but that's very different than, I'm just making up a number, $100 million. Why not just leave it with the jurors assume there's an amount of money? Wouldn't that make more sense rather than introducing this person's worth $2 billion? Why wouldn't that have an effect on jurors?
I think it'd make less sense. You want to have, at some point, you want to have an effect on the jurors. You want them, as you present your case, you want them to understand just how
Is that an
represents.
unfair effect, though, if we're just talking about was there a breach of duty? Well, I just want to punish this person who's has so much money. That means nothing to this person. So wouldn't that be in the back of the juror's mind?
I don't think so. I mean, you've got a couple of things that have to go on here. First of all, you have to show there's the basis for the punitive damages, that the conduct was reprehensible enough to fit the bill for the Raji instruction of what you need for punitive damages.
I think the argument is that it bleeds over into just the determination of liability in the first instance without even getting to punitives. It clearly comes in for punitives, but it came in as just part of the trial.
Well, yeah, and I believe it came in toward the end of the trial, if I remember correctly. But the point of that is you also trying to be fair to the person on the other side, because if their net worth really isn't that big, you're going to have to fashion punitive damages to sting them enough, but not destroy them. You don't want punitive damages so vast that they destroy somebody.
Mr.
But you have to.
Let me
Yes.
ask you, what harm would have been caused by bifurcation?
Well, it would have been number one, in general, you have a right to have one trial, not to have it split into two different segments. And number two is it makes it much more efficient as you're going through to gradually establish the amount of the damages, the size of the trust, and then the assets of the people that are defendants that you're trying to get punitive damages from. It makes it far more efficient proceeding to do it all at one time.
You're not arguing, just to clarify, you're not arguing that bifurcation was precluded. You're just, no. Okay. All right.
I think it was a possibility, and the judge in the judge's discretion decided, no, I think the way to do this is non-bifurcated. But at some point,
you wouldn't have been repeating the trial. You just go through and determine liability, and now you add into the determination of punitive damages, you get this additional information. I'm just not following what the rationale for not bifurcating. How did that speed things up? What wouldn't it have been? You still go through basically the same evidence that you're doing, and this is just an additional piece of evidence when you're making a punitive damages decision.
Well, in a sense, yes, but once first of all, you got to establish the liability to begin with, so that's going to take however long that takes. But as far as determining the amount of the punitive damages, you not only have to determine, well, what is the.
But what I'm getting at is, why is that relevant to the determination of liability? Why don't you make that determination and then let the jurors hear about the amount of punitive damages for purposes of punitive damages, the amount of wealth?
The jurors have to decide the amount of punitive damages that are appropriate in the context of the overall case, the overall reprehensibility of what's happened, the amount of damages that have been incurred, and the wealth of the defendants. It's all one thing. Normally, you deal with it all at one time and gradually develop the case so the jury understands.
Why can't you do that in steps, though? You make the first determination: was there a breach? Okay, now I'm going to consider that in conjunction with the person's net worth and determine punitive damages.
Well, mechanically, how exactly do you do this? Is it the same jury that's going to do it?
Wasn't that the proposal? That it would be the same jury, and this first jury would determine liability and compensatory damages and then move to punitives. Now, there may have been some other intermediate steps proposed in there as well, but that's exactly what was proposed, I think.
So they go through all this, they decide liability, then the same jury reconvenes, and for however long it takes to try to you go back to their original determinations and original thoughts and try to work out the reprehensibility and the balancing and the total amount. Seems like an awfully extended and inefficient way to do things.
Well, let me give you one point of comparison with aggravating circumstances in criminal trial. Other than prior felony convictions, that's what happens always. there are two steps in the trial, and that seems to either work or not work, depending on the specific case, but without much drama.
Yeah, it's a possibility that the judge could have done that, but sitting now, well, I suppose it's years later, years after all this happened and all the dust has settled, uh, this court really should not be substituting its judgment unless it thinks that the trial court somehow abused discretion in making this sort of a call. I believe and I submit that it's a request for efficiency and fairness, and to abide by the general rule that there should be one unified proceeding where everybody gets to discuss the reprehensibility, high, low, whatever it
But there's no
might be.
dispute that can happen if you bifurcate, and it's simply very much like in a criminal case. It's the same jury is there. They've reached a decision on that there is some liability. Now we're going to give you an additional fact. We don't give that to you in a criminal case because it's prejudicial, but it doesn't unnecessarily prolong the case, other than, I mean, there's a few hours difference, but they're not making the punitive damages determination until they get this additional information, but it's simply an addition to what they've already decided. So I'm puzzled as to why it wouldn't make more sense to bifurcate.
Well, all I can go back to, I believe, is the discretion that's accorded to the trial judge, sitting right there trying to decide, well, should this be one proceeding or two proceedings? What's the most efficient thing to do? What's the fairest thing to do for the jurors, for the court, for the lawyers, for the parties? And saying, well, in this case, I think we can get this done efficiently and well with one proceeding. And it seemed to go that way too. There was I mean, this what did this last 12, 13 days? The jury's working.
The court make a finding that it's not unduly prejudicial. It's clearly more efficient. Yeah, you save a few hours or a day or two, but don't you have to balance that against the potential for prejudice to the defendant?
Well, there again, isn't that an abuse of discretion call? What exactly is the prejudice here? There's no question that anybody working on this case as a juror would know very, very soon that there's an immense amount of money involved. I mean, Mr. Kunasek's small portion of this is many millions of dollars. And so if you just multiply by 10, you get some idea of the amount of money that's involved in the assets of the trust. And they'll start making inferences and extrapolations from that right away. And so they'll understand they're dealing with very wealthy individuals. The evidence of the net wealth was so quiet. I mean, you had 3 exhibits basically, and you're done. It was an efficient, logical way to do it in one proceeding. Now, you could have done it in 2. There could have been bifurcation, but in the end, it's really the trial judge that has to make this call of whether it's unduly prejudicial or whether there's greater efficiencies or inefficiencies. What's the best thing for everybody involved in this whole proceeding? The judge made a call. I think it was a good call, and I submit that the court should, unless there's something drastically wrong, honor that exercise of discretion and hold that it was logical and fair not to bifurcate. I have no idea what time I have left, but if there's
2 minutes and 50 seconds.
Okay. If there's no other questions, I think I've covered the main points that my colleague did. Let me take a look at my notes real quick here. I think I pretty much dealt with everything. If there's no further questions, I'll return my remaining time to the court.
Thank you. Mr. Silver.
Thank you.
Thank you, Your Honors. Mr. Kunasek is the one who called it a staggering damage amount, and I point you to the record at number 708 at page 18 to see that. Mr. Abney is correct. All he did on the punitive damages issue was introduce actually 4 exhibits, 4 interrogatory answers about net worth. It took minutes, one with each of these witnesses, but it caused a great deal of prejudice. And the court's guess as to what Mr. George Johnson's net worth was somewhat short. Let's just leave it at that. Actually, it's quite a bit short.
But Mr. Silver, if the jurors are going to be aware in determining damages that Mr. Kunasek just has a 5% interest, and they're suggesting it's a 5% interest that's worth $10 million, why would they not automatically extrapolate another 95% to that starts looking pretty staggering at any level?
Because the damages, he did not own 5% of what George Johnson owned. He didn't have a 5% interest in George Johnson. He had 5% interest in a trust that owned a business that had a contract with another business that George Johnson owned, and that contract was terminated. So if you put together the pieces where you have an expert who's saying all the losses were caused by the trustees, all that actually was lost was the right to get the benefits of a contract that could have been terminated at will, and the testimony was that the actual losses from the sale of these assets would 5% of that would have been about 1.5 million, or a little bit less than that. And you come with this judgment, this verdict that's $10.5 million. That clearly demonstrates that there was a passion or prejudice that was caused by putting this information in front of the jurors to begin with, which was exactly what we were seeking to avoid. If I can make a couple of very quick points on the issue of this Toy v. Katz. Toy v. Katz is not on all fours with this case. It's not even on 3s or 2s. It involved adding a new plaintiff under Rule 17. But Judge Hagee cited a case called Perez v. FedEx Ground Package, 5887 Fed Appendix 603, an 11th Circuit case that pointed out this is not, there are different jurisdictions approach this deeming issue differently, and there are cases that find against the idea of deeming it. There's Griggs v. Nash, 116 Idaho 228, and there's one that I can't pronounce, Avazoglu v. Drever Furnaces, 418 Pennsylvania Superior 111. Those find the other way. They find that we're not going to find the complaint deemed filed. And they do that. Some of them are just because they strictly follow the rules of procedure, others because no notice was given.
If you could just wrap up with, we'll give you 30 seconds to wrap up.
I appreciate that. Thank you. So, if it's clear that the jury's verdict is a result of passion or prejudice, a court shouldn't merely offer a remitter, but should grant a new trial. It is an abuse of the court's discretion to allow the wealth of the defendant in on the front end of a case when it is so clearly separate from the issues in dispute. So again, as a result of all of these different issues and the compounding of the issues, we're asking the court to find that the complaint was not filed timely, that even if there is an exemption for deeming it filed with the motion to amend, the plaintiffs failed the notice requirements here, and I guess at worst for us, it should be remanded to the trial court to determine whether actual notice was given, and there should be a reversal and a vacation of the damage award, so that this court can instruct the trial court to take steps to properly control what the jury is hearing and give the jury the correct roadmap as to what damages it may allow, what the expert witnesses may testify to, so that we can properly limit this to the bounds of reason. That's all I have. Thank you.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.